produced by Feed Families Not Pokies Aotearoa. We're an incorporated society with one purpose: to rid Aotearoa New Zealand of all pokie machines as soon as possible and forever by peaceful and lawful means. In this video we tell the story of how the Department of Internal Affairs, which regulates gambling in Aotearoa, has systematically and deliberately made decisions that the High Court has now declared to be unlawful. As a consequence of those decisions, there are currently more pokie venues in New Zealand than there should be. A little bit of context and some basics about the Gambling Act. The Act became law in September 2003. The number of pokies had increased rapidly in Aotearoa from the early 1990s. By the time the Act was passed, there were about 23,000 of them. Since then, there's been a steady decline. By early 2024, there are about 14,000 machines. That reduction happened because the Act does two things. The first is that every territorial authority, which is a district or city council, is required to have a policy on Class 4 venues. These are clubs and pubs that have pokies, not casinos. When a venue is closed for more than 6 months, it can't get a new licence without council consent. If the council's policy says that it won't grant a consent, that's called a sinking lid. The consent isn't granted, the venue is gone. The Act also has a built-in sinking lid on venues with more than 9 machines. These are venues that were in operation on the day the new Act was announced, which was 17th of October 2001, could have up to 18 machines. Section 90 says that the Department of Internal Affairs must keep a list of those venues, and sections 92 and 94 between them say that if any of those venues is closed for more than 6 months, it can only get a new licence for up to 9 machines. And as a caveat, that's only if the council policy would grant a consent, and a council policy can set a lower number than 9. Now, there are some exceptions to those sinking lid rules in the Act, but we might look at them another time. The gambling industry doesn't like these rules. It has concocted various methods and workarounds to avoid them. Sometimes they've done this with the support of the Department of Internal Affairs and the Gambling Commission. One of these workarounds was called Waikiwi Relocations. So in this video I'm going to tell you what they were, how they were supported by the Department and the Gambling Commission, and how we finally put a stop to them. All the sources for this video are available in the public domain or were obtained under the Official Information Act. Some of the material was presented in evidence to the High Court. There are links in the description below. We start with the Waikiwi decision itself, 2013. This was in respect of the Waikiwi Tavern. It's one of the venues that was on the list in section 90 of the Act, and it's listed as being at 35 Gimblett Street, Waikiwi, Invercargill. The venue had 18 pokie machines. The Invercargill Licensing Trust, which owned and operated the tavern, still owns and still operates the tavern, intended to relocate it a short distance to the corner of Gimblett Street and North Road. Under the Act, moving the tavern should have resulted in the loss of 9 machines. However, the Licensing Trust went to the High Court. It sought a declaratory judgment allowing them to move to the new venue and keep all 18 machines. That map is the Invercargill City's Online Geographical Information System, or GIS, showing the original location, the new location, and another land parcel at 23 Gimblett Street between the two. The Licensing Trust's key argument is set out in paragraph 8 of the consequent High Court decision. They thought that they could move the venue by amalgamating the title of the 3 properties, moving the machines from one end of the new property to the other, and then recreating the original titles. However, that would be tiresome and expensive, so they asked the court to relieve them of the effort. This was a ridiculous argument, for reasons we won't go into here, but somehow a High Court judge was persuaded to accept it anyway. In his decision, the judge said that the venue should be able to move without going through that legal charade, and he gave 4 reasons for allowing the move. 1. The change in location is minor. 2. The name of the tavern will remain the same. 3. The ownership and management of the tavern will not change. 4. For all intents and purposes, patrons and the public of Invercargill will regard the tavern as being the same venue, even though its physical location will change in a relatively minor way. These 4 reasons later became known as the Waikiwi criteria. Now, we think this was a terrible decision, and we really don't understand how the judge was persuaded to make it. Certainly, if we had been a party to these proceedings, we would have appealed this to the Court of Appeal. But, as it happens, water under the bridge, we shouldn't have needed to do any of that. Because, just a few months later, in the same year, after the High Court decision, Parliament amended the Act so that councils could decide whether venues, including 18 machine venues, can relocate. This is something that they could put into their Class 4 venue policies. In fact, they were required to consider that the next time they review the policy, which has to be reviewed every 3 years. That should have put an end to it, but it didn't. In 2014, so some months after the Act was amended, the pub charity applies to DIA for a Waikiwi relocation, for allowing a venue to be relocated under the High Court decision. And in a letter from the department back to the CEO of pub charity, they say that yes, the Waikiwi decision can exist alongside the amended Act if the word relocation is disregarded in the amended parts of the Act, including the part that requires a territorial authority to have a Class 4 venue policy. This is borderline insane, of course. You can't just ignore the words in an Act, but that's what they decided to do, and from that point onwards they started to allow these Waikiwi relocations. And they did this by applying the 4 criteria set out in the High Court decision. That went on for a while. In 2018, the department changes its mind. And again, in a letter that we obtained under the Official Information Act to Blue Sky Community Trust, Department refused a Waikiwi relocation, saying it would be contrary to the scheme of the Act if the Secretary could grant approval for a Waikiwi relocation where the territorial authority has a policy and consent for the relocation was not granted. It's a good letter, actually. It sets out a very robust, sensible and reasonable interpretation of the Act itself, including the amendment. We entirely agree with this position. However, that position is subsequently appealed to the Gambling Commission. In 2019, DIA refused to allow a Waikiwi relocation for the counties in Pokies, Auckland, and that refusal was appealed to the Gambling Commission. In a decision that was probably not within the Commission's legal powers, the Waikiwi relocations were allowed to continue, and DIA didn't appeal that decision to the High Court. So I just want to dig into this one a little bit because it's weird and interesting. This came about because the New Zealand Community Trust, NZCT, appealed against a decision by the Secretary for Internal Affairs refusing to change the address of the county's inn. Now, the highlighted little part of the on the right hand side there is from the Gambling Commission's decision, paragraph 1. the New Zealand Community Trust appeals under section 77(1)(b) of the Gambling Act against this decision not to amend the licence. And that's important because 77(1)(b), these are the powers of the Commission in regard to Class 4 gambling. So, a corporate society may appeal to the Gambling Commission against a decision of the Secretary to A. refuse to grant a Class 4 venue licence, B. amend or revoke a condition of the licence or add a new condition to it, C. refuse an application for renewal of a licence, D. refuse to amend a licence, and E. to suspend or cancel a licence. On the right hand side you can see an excerpt from the statement of claim for the case that we took to the High Court. And we're spelling out a very sensible, robust interpretation of what the Act actually means. A Class 4 venue licence includes both information and conditions. The information includes a description of the venue and its location. That's section 71F. The conditions are separately provided for in section 71G, 2 and J, and section 72. The location of a venue is not a condition of a licence. Therefore, going back to the powers of the Commission, the Secretary refusing to amend or revoke an address, the location of the venue, is something that the Gambling Commission simply can't consider. It's not within its statutory powers. So this leaves us with some unanswered questions. Why didn't the Department seek a declaration from the High Court after it changed its mind? Why did it just allow this to eventually go to the Gambling Commission? Was the Gambling Commission decision ultra vires, which is Latin for beyond its powers? On the face of things, we certainly think that's the case. After the Gambling Commission made its decision, why didn't the Department appeal the decision to the High Court? Now that the High Court has decided not to allow Waikiwi Relocations, should the Counties Inn now lose its venue licence because it was relocated unlawfully? And finally, what is going on with this tweet? A sharp-eyed member of one of the communities we work with noted this, found this on Jared True's Twitter feed. Jared is the solicitor who supported New Zealand Community Trust in front of the Gambling Commission. He does a lot of work with Pokie trusts all around New Zealand. And he's tweeted that he received a note of congratulations from the regulator regarding our recent Gambling Commission victory. This is a couple of days after that Gambling Commission decision was published. And he's got a little photo there of some sunflowers and a note. Hi Jared, it is good to have clarity from the Commission. I don't do wine except with some concession. And it's signed by Chris Thornborough, Director of Gambling at the Department of Internal Affairs. That we feel uncomfortable about that. Anyway, we prepared an explanation of the issues and a summary of the evidence, and then sought pro bono legal assistance through Te Araturi. Te Araturi was set up by the Community Law Centre Associations of New Zealand as a channel for low-income people and not-for-profit organisations like us to get free legal advice and support. We very quickly obtained the services of Matt McKillop and Asher Emanuel from Masons Lane Chambers in Wellington. They have expertise in civil litigation, public and administrative law, Treaty of Waitangi issues and other things. They read our brief and the overview of evidence. They said we had a very strong case and we filed an application for a declaratory judgment. Now, this is an application to the High Court to clarify and challenge matters of law and legal interpretation, as opposed to a judicial review, which tends to focus on specific decisions made by a decision maker. The case was heard in November 2023 and the decision was published on 19th of February 2024. Respondents were the Secretary of Internal Affairs, the Gambling Commission and the Gaming Machine Association of New Zealand. The Gambling Commission decided not to appear. The Secretary of Internal Affairs actually took our side. They stood by the position that they had taken in 2018 when they wrote that letter changing their mind. And so we were really opposed by the Gambling Machine Association of New Zealand. We won the case easily. Waikiwi relocations are no longer allowed. Unfortunately, we feel those that have been granted were allowed to stand. Justice Palmer, to be fair, saying that they should have to be reviewed on a case-by-case basis under judicial review, because the facts of each particular relocation may be pertinent. The Gaming Machine Association of New Zealand then appealed that decision, going to the Court of Appeal saying that Waikiwi was still good law because it allowed de minimis exceptions to the Act, and citing a whole lot of kind of previous case law where this has sort of been seen as acceptable. The Court of Appeal dismissed this appeal and reinforced Justice Palmer's High Court decision. And this is from the Court of Appeal's decision on this. Only councils may be able to decide whether a venue can be relocated. To conclude otherwise would blatantly undermine the purpose of the 2013 amendments to the Act. A council policy facilitates community involvement in decisions about the provision of gambling in a particular area. And that actually is one of the stated purposes of the Act, which it has been since it was passed in 2003. So, Waikiwi by the numbers. From 2014 to 2023, DIA received 33 applications for Waikiwi relocations. 24 of those were approved. 22 of them were for 18 machine venues. 21 were in districts with sinking lid policies. Relocations were allowed of up to 700 metres. And when we showed that evidence to the Court of Appeal, one of the judges said, well, that would rather appear to be de maximis, wouldn't it? 6 of the relocations were in Christchurch, following the 2010-11 earthquakes, despite the Christchurch City Council explicitly deciding not to change its Class 4 venue policy following those events. They wanted the damaged and destroyed venues to remain closed. Overall, 23 relocations were somehow contrary to a council policy, and we believe that these were not done despite the council's policy. They were done because of the council's policy. Justice Palmer described Waikiwi relocations as a workaround, and that's what they were, supported by the Department of Internal Affairs initially, and then reinforced by the Gambling Commission under quite odd circumstances. Where to next? Well, we're going to share the information that we've obtained under the Official Information Act with all the councils where Waikiwi relocations were allowed. We've got a fairly comprehensive bundle of information on each and every one of those relocations. We will be offering our support, analysis and advice should they wish to take a judicial review of any of those decisions. We would like to do that ourselves, but that is a massive undertaking, and we quite frankly can't afford it. We will be inviting the Gambling Commission to revisit the county's indecision and the scope of its own powers, and discussing that matter also with the Minister for Internal Affairs, sorry. And we currently have another action underway. We've gone to the High Court about the use and abuse of a power that the Secretary has under an obscure provision of the Gambling Act, which has allowed them to extend the time period between surrendering a licence and the requirement to get a territorial authority consent. That will be the subject of a whole other video, but it's quite an interesting one. If you would like to support what we're doing, you can provide support for our next case. This is the Court of Appeal case on section 71(1)(g) by going to Give a Little and make a donation there. The page is called Making Sinking Lead Sink. Any amount will be really helpful. Just a few bucks if you can afford it. And share the Give a Little page with your network on social media. That would be really handy. Thanks. You can like this video and subscribe to our YouTube channel. And as we produce more content about these cases, you'll be alerted to that. And you can sign up to become a member of Feed Families Not Pokies Aotearoa at our website www.ffnpokies.nz. So thank you for your time.